Good morning, everyone. We want to be respectful of time, so we're going to get started because I look over to my left and I see my delegation of I'm from LA down in Lower Alabama. And in my church, we had a group, and I want you to raise your hands if you are familiar with what you call the willing workers. Okay, yes. And that was the group, the delegation who you could depend on to do anything. It didn't matter what it was. If someone got the Holy Ghost and the Holy Spirit, they bring up something, let them sniff it, they just spring right back up, and the whole sermon would continue. And a lot of the faces that I see this morning are the folks that I call the willing workers. But you're also very important to DeKalb because you're the people that folk come to in the community because you're a wealth of knowledge. And it's very unfortunate, but in many communities, independent of you, they wouldn't get the memo. Even with over 780,000 residents, we do not have full participation in our newsletter. So those of you that are here, you heard about this. You probably received the newsletter, and thank you for being a willing point of contact in your communities. So this morning, I thought it was really important because if you're receiving the newsletter, I truly do my best to communicate with you in a way that we've not had previously. I need you to know what's happening in our communities. And this morning, primarily due to Senate Bill 406, because over the years I have had many conversations with possibly some of you in this room concerning your HOA and HOA practices. And many of you live in communities across DeKalb, particularly if you live in the south and east portion of DeKalb. We see a great deal of ownership by LLCs, Wall Street, and private investors. So there's an ongoing effort on our part to create good neighbors. And with that, we want you to simply understand the law. So this morning, I'm going to begin with some housekeeping. We want everyone to eat all of the biscuits and the yogurt and everything that we brought. Just get a little something in tummies. But also in DeKalb County, we have started a new era of sustainability. So do know that outside there are recycle bins. So we can recycle our plastics, we can recycle our paper so that we aren't creating waste. Our new motto in DeKalb County is trash is cash. And the more cash I make, the more good we can do for the community. So please recycle. Also, you'll see in front of you, we have little boards here, and you can actually use that QR code to access the documents that we're going to go over. But also, they will be coming out. We'll do a dedicated special edition newsletter that has everything going on here this morning so that people who didn't come out will actually still have access to the information. So I'm going to go ahead and get started. Of course, that's me, and welcome to our HOA Bootcamp. This is a part of our summer education series. And today we are joined by experts. Believe it or not, I think there's a lawyer that's an expert in every field. And this one just happens to my right to not only be an expert in HOAs, but he is also an elected official. You sit with Fulton County, correct? Yes, Fulton County Board of Commissioners. So today we have joining us the Honorable Marvin Arrington Jr., who happens to also be an attorney and a commissioner. And also, we have joining us Corro'll Driscoll Sr., who is the co-founder, and he is also an HOA lobbyist. Thank you so much for being present with us today. We look forward to the information that you all will share. Okay, now on to the big thing. Senate Bill 406, it is now law. And Senate Bill 406 is very important because previously HOAs could foreclose on you for $2,000. It is now changed to $4,000. And to be honest, $4,000 is not much different from $2,000. It's absolutely unbelievable that you can lose your home over $4,000. And in some communities, in particular, some of my immigrant and refugee communities, they simply do not understand the process when it's taking place. So with those communities, I have to exercise a great deal of care in ensuring that they understand the processes. But we'll talk a little bit more about that, because across America, as far as I'm concerned, from the White House to the State House, I see laws that are contrary to home ownership for working class Americans. So SB 406 did place some guardrails around HOAs, because in some communities they have literally gone rogue. And that's not what they should be doing. So today we'll talk about what it looks like to have a good functioning HOA. And I'm not sure, but there's some HOAs that probably need to update your bylaws. Over the last several years, I've had folks send me bylaws that were in law school. I'm sure the other attorneys here know what a blue law is. And to give you a jovial example of a blue law, in the state of Florida, it's illegal to tie an alligator to a fire hydrant. Okay? So when I read some HOAs, they were full of blue laws, things that were not permissible, because we're going to come to a slide a little later. When it comes to law, you cannot, on the local level, create a law that's arbitrary to the state or the federal law, okay? And as it relates to our HOAs, they are really governed by the state of Georgia, okay? And to put it into layman's term, we call that the supremacy clause. So sometimes when y'all reach out, even when I have a heart to do certain things, I don't have the ability to enforce it. So when it comes to forced immigration, I don't have the ability to write a law that's contrary to federal law. If they come into DeKalb County, they've come into DeKalb County. There's absolutely nothing I can do about it. And I'm not going to give a false sense of comfort or lie about my authority, because then you lose credibility with people who are depending on you to be honest with them. So with that being said, we'll talk about those guardrails. We'll also talk about the new fees. And I believe we may be up to slide 6. I'm not sure, but at any rate, I'm going to go ahead and hand it off. But I do want to also say that, we have various QR code signs throughout the building, but I do believe what's sitting in front of you will get you where you need to go. And at this point, I am going to introduce the panel, and then I'm going to gracefully walk away. Our first presenter today is Commissioner Marvin Arrington, Jr. And Commissioner Arrington is an accomplished attorney, entrepreneur, and public servant who serves as the District 5 Commissioner in Fulton County on the Board of Commissioners. And he represents in his district a little over 180,000 residents across 8 South Fulton communities. A nationally recognized super lawyer for more than 25 years, he is partner at Arrington and Phillips, LLP, where he focuses on criminal, civil, intellectual, property, and homeowner association law. Beyond the courtroom, Arrington is a filmmaker, author, he is a community leader, he's certainly an advocate, and he's also creating opportunities that educate, empower, and strengthen Georgia communities. He currently serves on several local and national boards and is the executive sponsor of Fulton County's arts and cultural and economic development initiatives. Joining him is Corro'll Driscoll Sr., and he is one of Georgia's leading advocates for homeowners associations and community governance. As the co-founder of the Georgia HOA Alliance, he spent more than a decade empowering HOA leaders through education, training, and also legislative advocacy and strategic partnerships with local government that focus on public safety agencies. He's a respected HOA consultant, an author, and a community leader, and he works towards improving governance and building thriving neighborhoods. He's also the co-author of the HOA Handbook, and I'm pretty sure that you'll tell us how we can access that. And he served in numerous leadership roles, including HOA board, president, community advocate throughout the Metro Atlanta region. Also joining us today is Tanza Clark. And Tanza Clark is our Director of Code Enforcement, Code Compliance here in DeKalb County. And let me say to you, yes, we're going to give a round of applause to Director Clark because she is one busy woman. Now, let me explain. When I took office, January 1st, 2025, code compliance was averaging between 50 and 65 citations per month. Well, I am pleased to announce that now that we have cleared our lenses and we see the community all through the same set of glasses, we now average between 250 and 260 citations per month. So we are set on cleaning up DeKalb. And I don't care where you live, hopefully you're seeing us look cleaner. Because I don't care what you have, because to be honest, this whole code compliance thing has gone far left. We've allowed people to operate in comfort for too long. So you may have also seen this week our announcement of our enforcement of our blight ordinance. And it strategically focuses only on commercial properties as well as apartment communities. And it is for the record that when I leave, you will not have a Walden Pond, a Brandon Hills, or a Whitehall Forest. You will not allow people to live in conditions in which you would not stay. That's just not going to happen. So I want to say thank you for honestly enforcing our codes and helping us create a better environment so that we can recruit and attract business that gives more pride in communities. Also, and then I'll be real quick and take my seat, but my grandfather, I quote people all the time, used to say that growing up down there in Lower Alabama, they didn't have much. My grandfather was a sharecropper. And he would say that as a little boy, that when he grew up, the house that he lived in, if he looked down, he could study botany because there were so many holes in the floor. If he looked up, he could study astrology. And that if he stood still, he could take the air, the atmospheric pressure because there was holes all around. But the one thing he said is that his mom kept that house clean. We're going to keep this house clean in DeKalb County. We're going to keep it clean, and given time, we will get better. So now on to Director Clark. She leads the efforts to uphold property maintenance and standards and improve quality of life through proactive code enforcement. With nearly 18 years of service to DeKalb County government, she is recognized for her experience in policy development, neighborhood stabilization, and also operational leadership. She's helped shape some of DeKalb County's most significant code enforcement initiatives and continues to lead efforts that make our communities cleaner, safer, and stronger. And I'd like to also say, I believe we're almost at 90% on our gas and service stations with mandatory video surveillance, and she heads up that initiative. And as I take my seat, I will say that we had to figure out also, because the gas and service station isn't the place you should report in the morning as if you're going to work and stand there on the corner all day. So, you know, that's private property. And technically, how we had operated is the only way we could enforce loitering is if you call me and say, well, they shouldn't be on the side of the building. Well, what we found is me stopping in, half of the owners were afraid of the people standing on the side of the building. So we created a wonderful document that gave us the power of attorney on the side of the building in the corner. So now, for all of our gas and service stations who signed it, it is documented in the system, and as our officers are passing by, we have authority. If you're on the side of the building, we stop and ask you to get off. What are you doing here? You got business? Let's handle it and go. So now we are getting rid of loiterers. So I want to thank you, Director Clark, because again, it's all done through code enforcement. So at this time, it's my pleasure to turn over the presentation to Attorney Arrington. I prefer to call you that this morning. And also Mr. Corro'll Driscoll Sr., who will kick off today's HOA Bootcamp. Thank y'all for coming out.
Good morning, everyone. Make sure I turn this on. Good morning. My name is Marvin Arrington Jr. Thank you so much, CEO Johnson, for having us here today. Certainly a pleasure to be here with you. I'd like to start out by seeing a show of hands. How many people are on their HOA board?
Well, that'll do it.
Congratulations and condolences. You have been elected to the board for the rest of your life. You will never get off the board. There will never be a quorum. You'll never be able to move on to anything else in your life. You will die on the HOA board. But seriously, thank you guys for being here. Thanks for having us. Mr. Driscoll and I, are homeowners like all of you. And in 2013, we were having issues with our HOA. And we started looking around for answers. And we found that those answers were in the subdivisions next door and down the street and around the corner. We went to a website that had just started at that time called Nextdoor. How many people are familiar with Nextdoor? So in 2013, Nextdoor was just getting started. But the real answer is that we found that the answers to our questions were with other homeowners, but we as homeowners were not talking across subdivision lines. The builders, the management companies, the developers were all talking across subdivision lines. And so we were able to find the answers to the questions that we had by not just reaching out to our immediate neighbors, but our neighbors in a more general sense. And so, basically as a result of what we went through, we founded a nonprofit called the HOA Alliance and decided to pay it forward because we got so much help from our greater community. We felt responsible that we had to pay it forward and help others with their issues in their communities. CEO Cochran is right. The way the current Georgia law stands, your home could be foreclosed on for up to $2,000, right? And there are different types of associations. Let me back up a little bit. So most HOAs are first and foremost Georgia nonprofit corporations, and they are subject to the Georgia Nonprofit Corporation Code, okay? There are also condominiums. Some of you may live in a condominium, and most condominiums, depending on when they were formed, are subject to the Georgia Condominium Act. A lot of the older, more traditional HOAs are just subject to the Georgia Nonprofit Corporation Code and the Georgia Real Property Act, right? And so those are what a traditional HOA is subject to. The Condominium Act is different because you have people with homes on top of each other. You have more common areas like the roof and the sidewalls. And so there are different rules that apply for condominiums. How many of you have heard of a POA? Okay, POA is the Property Owners Association Act. And basically what that was an attempt by the legislature to make a traditional HOA more like the condominium, subject to laws more like the Condominium Act. The Georgia Condominium Act, all of the laws are under one act, under one general thing. With a traditional HOA, you kind of have to apply the Real Property Act to the Georgia Nonprofit Corporation Code. And so POAs are a way to take those traditional HOAs, put them under a POA so that it operates more like the Condominium Act and everything is all under one act. But yes, people's homes were getting foreclosed on for $2,000. And let me tell you the way it works now. Right now, you could owe $500. They could hire an attorney, pay that attorney $1,500, and now you have met the $2,000 threshold for your home being foreclosed on. So really, you're not even getting foreclosed on for $2,000. You're getting foreclosed on for $500, right? And so, thanks to Mr. Driscoll and myself and others, we've been working on trying to get these laws passed. Frankly, since I first took office in 2015, because we were already dealing with HOA stuff. So it has been a long battle, but SB 406 is transformational. And not only for what it's going to do here in Georgia with HOAs, and frankly, what we call the general area is community association, because it could be a HOA, it could be a condo association, could be a POA, or any other type of association. How many people remember co-ops, right? So co-op is another form of a community association, but HOAs and condo associations have kind of replaced most co-ops, although there are still a few co-ops that exist. And so, what happens is SB 406 basically turns the table on that, and we'll kind of get into it as we go here. I'll just let you know quickly, this passed 51-0, unanimous vote in the Senate, and in the House, it passed 155-10. On May 12th, it was signed by Governor Kemp. So it has strong bipartisan support, right? Because this is not Republican or Democrat. This is helping Georgia homeowners, right? In the state of Georgia, there are over 12,000 different community associations with about 3 million people residing in those associations. Does anybody know how many different set of rules there are for those 12,000 associations? 12,000. And therein lies the problem, right? Therein lies the problem, and that's where SB 406 helps. But this is transformational because Georgia is leading the way. Georgia is leading the way, and frankly, I think other states are gonna follow Georgia. They're gonna follow this example because everyone's having the same types of problems. So if you think about it, we got all these new things, CEO Johnson, we got pad split and Airbnb, right? Yeah. And if you live in Hilton Head or Miami on the beach somewhere, you probably love Airbnb. Mm-hmm. But if you live down the street, Airbnb might not be your best friend, right? So, that gets us into, why this boot camp matters and why we're here to talk about SB 406 specifically, and hopefully address some of your other questions. CEO Johnson already talked about the supremacy clause and how federal law trumps state law trumps local law, county and or city. But the main thing, yes, okay, thank you. So one of the main things is that is important for you to know is that so let me be careful as we talk about this. I want to be very specific. Your governing documents, the Declaration of Protective Covenants, sometimes it's called the Declaration, some people just call it the Covenants. It is the Declaration of Protective Covenants. And that Declaration of Protective Covenants, along with your bylaws and the other rules of your association, are a contract between you and your association, okay? That's very important. The Declaration of Protective Covenants are a list of rules and restrictions that run with your land. So when you get ready to sell your house or move, those restrictions and those land use restrictions run with the land. So I go out and I buy 100 acres, and I say I want every house in these 100 acres to have a pink door. And if you sign up to buy a house in my 100 acres, you are agreeing that everyone in the subdivision will have pink doors, okay? And so that is what happens. Now, you have bylaws, and I try to make sure that this is clear for people. The bylaws are the rules that operate or govern the nonprofit association. How often do we have meetings? How do we conduct elections, right? So the bylaws run with the company, and the Declaration of Protective Covenants runs with the land. So I did kind of talk about this a little earlier, but HOA, POA, Condo Civic Association, 90%, or probably more like 99%, of all HOAs require mandatory membership. So when you buy a house, you buy that house subject to the recorded Declaration of Protective Covenants, right? And you are subject to all of the rules that are part of that Declaration of Protective Covenants. There are some in DeKalb, see Rod over there, there are some civic associations that have voluntary associations, but that is the exception, not the rule, right? And so most of the times you don't have any choice. I didn't have any choice. My ex-wife said she wanted that house. It didn't matter what I wanted. That was the house we were gonna get, right? And whatever those rules were, I was gonna have to live with them, all right? So let's go move to the next slide. Is the association incorporated? Are the amendments recorded? Has the board been properly elected? Are annual meetings being held? Do you get a copy of the annual budget? These are all things and obligations that your association is required to do typically as part of the Declaration of Protective Covenants and the bylaws. And I don't know specifically about your association until I see, because again, there are 12,000 different rules. So your specific association may have some different rules. CEO Johnson talked about amending the bylaws, right? And while that is good, sometimes it becomes hard to do, because if you don't have a quorum, if you don't have enough people for a quorum, then you can't conduct a meeting, right? When you can conduct the meeting, you just can't pass anything at the meeting, right? And then amending the bylaws typically requires a supermajority, 2/3 of all homeowners. Well, if you can't get 25% of the people, how in the world are you going to get 66% of the people, right?
And I have to pop in here because in certain communities in South and East DeKalb, because of the large presence now of LLC, Wall Street, and private investors, most of the homeowners in some communities in DeKalb, and as best we can tell, and this is problematic for me, the General Assembly does not allow me to have a rental registry, which would require an owner to register with DeKalb if they are a non-owner resident. That way I can get to you, because this is very problematic for us, and I know Director Clark is problematic for you, because the overwhelming majority of code violations that we see aren't by owner occupants. These are folk who don't live in the home, but we can't reach them because it requires that we give you service notification. So it is very problematic. And, I'm wondering if there is something that, maybe this year we need to carry legislation from DeKalb County requesting that there is an exclusion of non-resident owners from the voting process so that communities can get things done. Now, with me sitting next to a legislator and an expert, Do you think we can make that happen? Now, and let me be clear, just because they say no don't mean I will not ask.
Well, the short answer is yes, right? The short answer is yes, but, I think that is where really these HOAs can help. The HOAs and county government can come together, because although the county may not be able to do that, as a HOA, you can require that information and then partner with the county to maybe even provide that information to them, right? So a HOA board certainly, I believe, has the authority to find out who is renting in their neighborhood, right? And so although the county, again, may not have that or authority to do that, HOA boards can do that, right? And so that may be an opportunity, CEO Johnson, where, the HOAs can work with the county to help facilitate that information process.
And let me say this, currently, the most accurate way we have to determine whether or not it's non-owner occupied is homestead exemption. And in some communities, over 60% of the residents have not filed homestead, and those are the communities where we have a strong belief that these are non-owner occupied homes.
Can I speak to the elephant in the room? The apathy also can be overcome if we all come together to help push these legislative initiatives. So there were quite a few homeowners who spoke up at the Capitol, Camille being one. I don't know if we have any others out here. She's from DeKalb County. And so it would be great for you all to have a discussion with her, because she spent a lot more time than I did up there. But we have to come together and help these policies get pushed, because we elect these people. I just wanted to add that.
And let me say, I will go back and we'll have that drafted, because currently we're in the process right now of formulating our legislative agenda for 2027. We don't wait until November anymore. We've been doing it early, and actually usually in September, we come together and we actually present it to the delegation. Now, this is very important too. You all have to show up, because too few people know the foolery that's going on down there at the Capitol. And sometimes it's important for those who choose the wrong path to look you in the eye as they do so that at least they know whether or not you do the right thing. We're watching. And also, I have to say that for the first time ever in 2026, we had a unified agenda of priorities with the Metro leaders. So myself, Nicole Love Hendrickson from Gwinnett County, who is their chair, Lisa Cupid, who is the chair of Cobb, Rob Pitts, who is the chair of Fulton County, myself, as well as Alika Anderson Henry, who's the chair of Clayton. Those are your 5 largest jurisdictions. We're also the target of House Bill 369, but I won't go into that. But we actually created this year for the first time ever a unified agenda, because we realize there's strength and power in numbers. And if all 5 of us from the largest jurisdictions are showing up and saying, we have independent agendas, but as a metro, we're concerned with these, I'm going to add this to our metro unified agenda, because issues don't change from one jurisdiction to the next. People do, not issues. So I'm going to do that.
No, that's so good. And thanks to Senator Warnock and Senator Ossoff, they just got that new housing bill passed to prevent a lot of this corporate buying of homeowners, homes in subdivisions. We got companies buying the whole subdivision and renting it out, right? And so so it's important that was done, and thank you, CEO Johnson, for your efforts locally in that. So let's get into SB 406. So SB 406 is broken up really into 2 parts. The first part actually became effective on July 1st, which is the attorney fee portion. which basically says that attorney's fees, there is a new process for attorney's fees and that there will have to be a hearing with the Secretary of State. The remaining portion of SB 406 doesn't come into effect until January 1st of 2027, okay? And what it requires, it's going to require all HOAs, all community associations, to register with the Secretary of State. They'll have to pay an annual fee of $100 to register with the Secretary of State, and then a $100 annual renewal. And those registrations are annual, so they expire December 31st of each year. You know, you'll have to report changes in name, address, and officers within 30 days. So,
Now, I have a question about that, because here we go with fees again. If a community association fails to register, what are the consequences? Would it be that they're deemed ineffective and cannot enforce their covenants?
that is absolutely correct. You will not be, if you do not register with the Secretary
That
of
was a
State,
good question.
you will not be able to, you will not be able to collect dues. You will not be able to collect any membership fees, assessments, or dues if you do not register with the Secretary of State. You lose the ability to enforce your declaration of protective covenants. It doesn't mean that those covenants go away, but your ability to enforce them goes away if you do not register, right?
Which would also mean they could not collect dues from members.
Which means you cannot collect dues from members, right? You can't, not only can you not collect dues from members, you can't file or record any liens if you don't register. You can't initiate any foreclosure.
Yes,
Yes.
sir.
I understand that you say you cannot enforce the collection, but you can still collect dues.
No.
As long as they pay them, no? If you say here's the invoice for your annual fee, if they don't pay, you cannot enforce it, but you still can send out an invoice for collection.
So, yeah, so, I mean, well,
Send it out.
you can send it out, but they don't necessarily have to pay it, right? And they could voluntarily pay it just because
Right.
you're a good person and a good
Right,
homeowner.
exactly.
And you know that that money is needed to
Right.
make the association
No,
go
and that's why I
forward.
want to make sure that
wanna be
distinction
clear.
between I can still send out the invoice, I cannot enforce the collection of the invoice.
That is correct. That is correct. And the homeowner can still pay it, right? Even, I can send my dues in before you send me the invoice, right?
So let me help offer some clarity here. The whole purpose here is for the community associations to abide by their own rules and the rules of the state and the federal government. So if they're not registering, we're talking about two different registration, and one specific to Senate Bill 406 is that $100 a year fee. Now, I know you've heard of the Community Association Institute. They have spoken as though that was a pain for the communities, and it's not. And they are actually helping the Secretary of State come up with these processes. So the battle is not over, folks. We want you all educated, but we want you to keep a watchful eye. So if they don't follow the rules, then they cannot collect or enforce. $100, if they're not paying $100, we got bigger problems, right? So.
So I see we got a question up
Yes.
front and then a couple more questions. Yes, sir. And then we'll come to you, ma'am, and we'll come down there.
I wanted to ask, does that include voluntary HOAs? Because we don't have a covenant, it's totally,
I will have to look at the law, but the short answer I want to give you is yes. It covers all community associations in the state of Georgia.
But
Right.
now, and let's dig a little bit deeper on, take that layer off the onion, because when it comes to voluntary HOAs, to be honest, it is only through consent. So a voluntary HOA, to be honest with you, if people say no, then there's really nothing you can do about it. And I'm just being honest. You know, right now I'm dealing with a community where they have a huge monumental gate over near the Southland that you all may be familiar with. And someone took the liberty of, I guess, doing wheelies or whatever, and they ran into it. And they reached out to us about it. And when we checked, you know we're going to check. It sits on private property. So to be honest, the homeowner is responsible for fixing the monumental entry. But the community, it's an eyesore to the community. Now, you would think in a good and decent environment, the neighbors would all show up with $150 or $200. Well, no, that's not happening. So now they want me to legislate morality and decency. And I can't make him go out there and fix that sign. But now what we can do, because when he bought that house, there should have been an inspection. There should have, you know your property lines. You knew it was sitting on your property. So unfortunately, now that I'm aware, you're going to have to fix it. And this is a $10,000, actually, I think it's a little more than that situation. So we've done our due diligence. We've now issued citations, and now it's going before the courts.
It sounds like that Director Clark, right? Code enforcement.
We're going to enforce codes because, you know, now if you want to pick up all the bricks and move them, you can do that too, you know, but you're not going to have that pretty entry, and shame on y'all for wanting to make your neighbor build you a new entry. But
now that's a unique situation because typically those monumental entries will be on common property and not on an individual's property, right? And so if it is on his individual property, it is his responsibility. I know we had some more questions. I just want to, yes, ma'am.
Yes, good morning. Thank you all for coming to educate us. My question about the $100 initial filing fee. So what we can do is go to the Secretary of State's office to see whether our association has met that fee. And if it's voluntary, if they haven't, and they send us our assessment for our annual fee, if it's voluntary for us to pay it, my question is, if they don't pay it, and then later on they decide to pay it, do the members or the community members have to send that fee in because they're now in good standing with the Secretary of State office? Or is it waived?
Well, you know, so all of this is new law. The Secretary of State has not adopted the policies, practices, and procedures that will go along with this, right? And so it's hard for me to give you a direct answer, but I think what CEO Johnson said is correct, right? In a voluntary association, it's always voluntary, right? But 99% of these associations are mandatory. And so, again, I don't think they don't lose the right to collect it because you've got a written contract. You've got a written contract that requires you to pay those dues, right? But the ability to enforce that written contract is now being regulated. HOAs were the #1 unregulated industry in the country until now, right? And Georgia is leading the way. Now, I want to get back. I know we have a couple more questions, but I just want to say this. What this does is it establishes a complaint process. SB 406 establishes a complaint process so that if you have a problem with your HOA, you don't have to go hire a lawyer and pay them $5,000, $10,000, $15,000. You can have a hearing before the Secretary of State's office, right? And so this is a great way, again, to rein in these HOAs.
Can we save it for questions and answers?
Yeah, I think we got a question and answer period on there because we'll never get through all of this if we keep answering questions. I know we did have one question here, yes, ma'am, and then we're going to try to keep it moving. I'm going to try to move as fast as I can.
It was for the fee to, basically 2 questions. The first one, if it's going to be through a fiscal year or calendar year, and then my second question is, let's say it's a calendar year, we pay and the HOA doesn't register in January. Let's say it registers in March. Then once they're registered, can they retroactively be like, oh, now you have to pay us for the months that we weren't registered?
So let me get
Or do they start once they are?
Yeah, I think I think that's a similar question to what she asked. Again, I think you have the duty pursuant to the contract to pay your dues, and it's just a matter of the enforcement of it.
I think what you just described is what I now call a Trump moment. That's what I call it when you create a law and it's ambiguous, because it tells you you don't have to do anything, but then there will be consequences on the back end when you don't. So what we're going to do here is put it all out on the table, and even when that HOA is not in compliance, my Alabama wisdom tells me, by way of Georgia, that when they do become compliant, you're going to have to pay. And, you know, you can do the Trump moment and go to court and let the judge tell you, but now at least you go into the Secretary of State, and at least you're saving the fee, but you'll end up having to pay it.
So if I can ask everyone
In
to
my
just
opinion.
write your questions down for me so we can keep moving. But if you have a complaint with your HOA, you have 180 days to file that complaint. So if you're a homeowner and you think the board did something wrong, you have 180 days, 6 months. So don't let that time slide by because you may waive your right to voice your complaint or to have the Secretary of State's office or to have a hearing on it, right? I don't know if anyone's had a DUI, but it's a similar process. You get a DUI, they take your license, and then you have to request a license suspension hearing with the Office of State Administrative Hearings in order to get your license back.
So if I can add, the first part of the law is what, 24 days in? So dating from July 1st, we could start that count. Well, 6 months to Jan 1st. So if you're going to complain, if you got some things going on, take COPA's records, keep all your evidence, and get prepared to take out your complaint. So it has started as of July 1st.
Well, yeah, but I think only the attorney fee portion is started as of July 1st.
But I'm saying the 180-day count from January 1st.
Yes.
So if I have some pending issues with my HOA that started, let's say July 1st, then that 180-day count start. So be prepared to take out your complaint once all of these rules and the processes are released to the public. Pay attention, folks. Don't ever take your eye off this. CAI remains in the mix. That's all I want to say.
So just try to get through as many of these as I can. I know we have limited time, but board authority has limits. Boards do not own the community. They are elected. As homeowners, you have the right to elect the board and to replace the board. But once you elect and replace the board, then the board has the authority for running the association, similar to the Board of Commissioners, right? You don't have the right to go down there and take over the meeting from CEO Johnson, right? But you have the right to elect her, right? And your other representatives.
Board of Commissioners.
Yes, the Board of Commissioners, right? Yeah, no. So directors have a duty of care. They must disclose their conflicts, and they must keep records. And so I'll just go there. That community money is not the
Senate
board
Bill
money.
406 makes that clear. All
Yes.
of the duties that the board owe to you as members, it is codified and clear. It's always been codified, but now it's a little bit clearer. This is just a great start.
Now, and I'm sorry, because I'm kind of telepathic, so I saw a hand or two go up. What is the recourse when the governing board isn't doing their job? I see. I deal with so many of you, I can already tell what you want to know, okay?
So great question. Your recourse is to file a complaint with the Secretary of State within 180 days, and they will schedule a hearing, and you will be able to go in front of an administrative judge so they can hear your complaint and make a decision instead of having to go file
But
the
do
lawsuit.
not look past your governing documents, because it does outline a process for the members. But if they don't follow that process, during that 180-day period, like you may put out a collectively 25% can request a board meeting to remove the board members. If they don't honor that, make that a part of your complaint. And so, just again, I tell you, I used to read my governing documents all the time. It worked on putting me to sleep. And since I stopped reading them, I have sleeping issues. So read your governing documents. It works.
And also let me say, I've always been one, when I show up with an issue, I bring a solution. So when you go down there and file,
Yep.
make sure that within what you state, that you are filing due to a lack of care, because, when you assume certain roles, you become a fiduciary. Seek specific performance, and ask that the person be removed for cause. Okay, you got all three of those. If you didn't, call me later.
But you also have to make sure you're following your set of the 12,000 different rules, because that administrative law judge is going to make his ruling based on your specific declaration for your community. Okay, I see your hand, ma'am. We're just trying to get through as many as we can of these slides, because we got limited time.
Probably has 70 slides.
But community money is not board money, as CEO Johnson just spoke about. There's the budget, there's the assessment, there's the collection, and there's enforcement. And SB 406 puts guardrails around all of those different processes and all of those different duties that the board has. Budgeting basics is our next slide. What the real budget covers. It covers the operating the budget, the reserves, insurance, landscaping, utilities, legal, collections, and capital projects.
Insurance?
Insurance is one of those as well. So if you're on the board, you want to make sure that most HOAs have proper insurance. But one of the things, if you're on the board, that you want to make sure that you have is E&O insurance, errors and omissions. And some people call it E&O, some people call it D&O, but it's the same thing. It is directors and officers insurance for errors and omissions. D&O is directors and officers. E&O is errors and omissions. You do not want a decision you make on the board to result in someone suing you for your house. So you want to make sure that the association is covering you for any decisions that you make. That is super duper important. You also want to make sure, if you're on the board, that you have a reserve plan. You want to know, you need a reserve study to tell you how much money you need to have in reserves and how much money you need for capital projects over the next 10 or 20 years. And you want to have that reserve study updated probably every 5 to 7 years or so.
And by a show of hands, I'm just curious, how many of you in here know that you have E&O, errors and omissions insurance? Okay, that makes me feel better, because, with what you do, there comes liability. And if you may be found on the adverse side of law, then it could have financial consequences for you serving on boards. And I've seen that before. They wanted to be in charge, but now they're in charge, and now they have and they've been held liable. And you would have to pay that out of your pocket if you don't have that E&O insurance. So make sure you have it if you're going to serve.
Let me add a little value around the budget for the board. When you establish that budget, that is your measuring stick for the members. So, avoid going outside of the budget to make purchases unless it's an emergency, because I've seen it over and over again as I speak with communities. You'll see that they won't take care of the existing amenities, but they'll go out and buy additional or purchase anything for the other amenities before they take care of the commitment that you signed the contract to abide by the governing documents in your community. Budget is a measuring platform for members in the community for your board.
And I'm going to turn it over to Mr. Driscoll. We're getting out of my legal expertise. I'm going to let him talk about financial management and move these slides forward. But, that is so true with the budget. And again, you must keep all your records for at least 3 years, and that's one of the things that SB 406. You know, quick aside, Mr. Driscoll and I were involved in a litigation. One of the community members in our association, C.O. Johnson, you'll like this. She reserved the name Regency Oaks Clubhouse at Yahoo and said that that was her personal email address. Now, and she was an officer. She was on the board when she did that, right? And so we were of the belief that that email address should have been owned by the community, right? It didn't say Marvin Arrington Clubhouse, right? It said Regency Oaks Clubhouse. But her argument was that it was hers. But I bring that up to say that there are opportunities for gray areas, right? Because the association has the responsibility to maintain those records for 3 years. So we needed access to that email address and all of the clubhouse reservations, all of the money that was paid, all of those things going through there. So just be mindful of that as you're operating. As an officer, and I won't get into that now, but there's a difference between when you're elected to the board, you become a board member. Typically, most associations then require the board members to elect officers. And so you have to wear different hats at different times. You may be wearing your board hat at one time. At another time, you may be wearing your officer hat. And at another time, you may be wearing your homeowner hat. Or sometimes you may be wearing all three at the same time. So I'll just bring that up briefly.
All right. So I just want to really jump into back into the processes as dictated by the governing documents. When we talk about dues increases, it has to be done in a proper fashion as outlined in those governing documents. So say, for example, the board has determined that the costs to maintain the community has increased. So based on the governing documents, they do have the authority to increase the dues or even establish a special assessment. But at some point, in many of the governing documents I've seen, I know in my community, you're supposed to involve the members, and it's generally at the annual meeting. So if the board comes to the annual meeting in a malformed fashion, meaning you hadn't sent out the budget, sometimes it's 2 weeks before the meeting, sometimes it's 3 weeks, it can be up to 30 days, then you're operating outside of that process. What this slide is talking about is follow the rules, because you have to be held as accountable, meaning not as individual board members, although some members may think you should, but as a community, you have to abide by the rules. You're held to a higher standard. I learned that during all the litigation process. A mistake of one board member sending out a violation letter 1 letter earlier put us in a compromising position. Follow the rules. If you don't know your rules, either get off the board or take the time to learn the rules. That's just my advice. I'm not scolding, right? I spent many nights reading that.
Well,
probably why I'm divorced now.
And
Did I say that out?
And to that point, you know, about following the rules, you need to, you know, for lack of a better term, your Declaration of Protective Covenants is your HOA Bible. It is your HOA Bible. Also, I saw one of my classmates from United Way VIP. The United Way has a board training program, a nonprofit board training program called United Way VIP program. It's run by a lady named Janice Robinson. And I won't date ourselves on how long ago we took the class, 1990 something. But it trains you individuals on how to serve on a nonprofit board. And that could be any type of nonprofit, right? But it is good, and one of the things we always tell people, get board training, right? Because we have homeowners that have not served on boards before. I need to know that. I see your hand, if you will, just
hold on to it.
Come on.
So what if you find yourself swept along with the board that's gone rogue and not following those?
I'm sorry.
As a board
I can't hear.
So if you're on, I think her question was, if you're on a board when the board is operating rogue and not following the rules, what can you do? Starting January 1st, you'll be able to file a complaint with the Secretary of State. Right now, there's not much you can do other than hire a lawyer and go file a lawsuit or file that lawsuit yourself. But that really isn't working for people, and that's why this new process and new system was adopted.
Okay, so let's move on to this next one. All right, so financial reporting has always been a requirement in governing documents, especially at an annual meeting. I think what we've seen now with Senate Bill 406, it's made mandatory that those financial reports are provided to the Secretary of State. So as a member, your rights are still in place where you can do an open books and review. I know some of us call it an open records request, but technically it's called an open books and review. Now, when I did it, I was a little sly with it. I didn't want them making me copies where I had to go and pay for it. I took my printer on my shoulder, it was heavy, and I went in and I scanned everything. I didn't look at nothing until I got back home and I took my time. So your rights remain in place. Board members, financial reporting is required. Balance sheets, the general ledger, I would make sure I have that all available for my members. And I know in some cases, I've been denied access to the records, so I'm just letting it play on into past July 1st, and I'm just going to wait till I get in front of the Secretary of State. I'll probably be one of the first few, so.
So you do have the right to request HOA records, and I think that's what Mr. Driscoll was saying, but they also have the right to charge you for making those copies.
Yeah.
And so that's why he took his printer on his shoulder and scanned all the stuff so that he did not have to be charged
And
for
they were
those
laughing.
copies.
They brought all the records out there to me. I'm like, okay. I just scanned them all in. Just scan them all in. Whatever it takes to get to satisfy your question. One thing I do want you to avoid making claims of theft, corruption, any of that. Do not talk to your neighbors or fellow board members about someone stealing. Because what I learned going through that process is they have to be convicted by a trier of fact. So even though you have that bad check in your hand, they have not been convicted. I've been sued. How many times?
And you could be subject to, libel or defamation claims, right? So,
That part.
and usually
Yeah.
most people are operating in good faith, right? Most people, but it only takes one bad apple.
Outliers.
It only takes one bad apple to spoil the bunch.
And I know by default, board members say, hey, I have a job, so I'll just trust a management company to take care of all of our operations. You can delegate responsibility, but you can never delegate accountability. Board members are still held to account. So follow these rules, provide the open books request, allow people access to the records. They're entitled to it. It has always been specified in state code. Now Senate Bill 406 has further enhanced it. Now you have to provide those financial documents at least once a year to the Secretary of State. So just pay attention, folks. And I'm talking to my board members. I can sympathize with both sides because I fall on both sides. Oh, questions at the end? All right. Can we get her a mic? I'm sorry, it's hard for me to hear you. I know we want to hold the questions to the end, so we'll let this one come in. That's okay. We'll let that one come in, but we need to get through.
Okay, just one quick question. In regard to what you were saying, I understand the open book policy, that is a must. But within those documents contain homeowners that have not paid their dues, and their address is linked to those non-payments. Is that not illegal for another homeowner to capture that information?
So there
I am
are
glad
certain
you asked that
records.
question.
Yeah, there's certain records that have to be disclosed and certain records that do not. And you cannot disclose whether someone has paid or not paid. Now, you can post a list of people that have paid, but you cannot post. You cannot post a list of people who have not paid.
Right, that's posting the list, but in the open books I'm not a practicing attorney, so I'm tales from the trenches type of guy. So as members, we are entitled to that information, but it's subject to approval by the courts, I would say.
Well, subject to approval by the courts and also subject to approval by the board.
Yeah.
The board is going to be the first decision maker on what can and cannot be released, right? And so typically they just have to give you kind of the budget documents and the outer documents, and they don't have to give you the monthly bank statements and all of those things. Now, I say that, but I believe that board members, individual board members should have unfettered access to any and all records if you are on the board. You should have unfettered access to any records if you're on the board. But you do have to be careful about disclosing people's personal and or private information.
Well, their names is in the membership database, right, which members are entitled to. I just know that from my experience, depending on the board members, some have been restrictive with providing the information, and you have to submit a request to the board, and they can deny it, right? And then, of course, you have to take it a step further. Now we have the Secretary of State to jump in and help us out with this. Now, we don't want to overburden the Secretary of State with complaints. This is why I recommend keeping records, copious notes. If I call, I don't believe in calling. I believe in writing my stuff down, emailing it over. I have a paper trail. But if you happen to be on the phone, you make sure you note what, from your perspective, what took place on the phone call. Send it over to them and say, hey, this is my understanding. So if they don't respond, then your understanding is accepted.
So, and with the open records request, there's a specific process and a specific statute that you have to follow. Mm-hmm. You have to let them know why you are requesting the records,
That's
right?
the
You have to let them know that it's not being done just indiscriminately. You have a specific purpose, and there's a specific statute that you have to follow. So you want to make sure that you follow that specific process. But this next slide, y'all, is the most important slide for all homeowners. This is it.
Yes. I'm speaking with a member out of Lawrenceville who's dealing with this type of challenge. Now Senate Bill 406 specifies when you make a payment, it falls in this order. Before, you will have some communities that would apply it to attorney fees before it even applies to your dues. Maybe you're a little
No,
delayed.
in fact, that is the standard practice of all associations currently, right? You have a past due bill, and most declarations actually even state this, right? That the association has the right to apply your money. You owe $2,000, you send in $1,500. That $1,500 goes towards their attorney's fees, so your bill never goes down. And you get stuck in this endless cycle because the more you fight, the more your attorney's fees go up, and you keep paying and you thinking your bill is going down. Your bill isn't going down, the attorney's fees bills are getting paid. And so that is why this is the most single important slide of today, because it establishes this waterfall schedule, which means that any payments that you make have to go towards payment of your regular assessments and dues first.
Right.
Right? That is the most single important part of all of this, because your dues get paid first out of any money that you pay.
Right, and that, with the attorney fees, we hadn't talked about that, or we're getting to the level where they can foreclose on your home. Now you cannot apply fines for violation of the covenants. That can't be applied to the total amount to initiate a foreclosure. And this is why we have to pay attention. When you get those processes, even if you don't plan on filing anything from the Secretary of State, take a look at it.
And according to this schedule, attorney's fees, late fees, and interest is now number 4. It's now at the bottom. Everything else gets paid first.
And this is how many people were forced out their homes. because this was taken care of first.
Yeah, and an important point on that slide is the fact that, it used to be 2,000, it has now gone up to 4,000 or 1 year, assessments unpaid for a year. So it kind of increased a little, but it may or may not increase. If you live in a condo, a lot of people that live in condos may be paying $200, $300, $400 or more per month. So if you get behind by a year, that's a lot of money for the association to absorb, right? Typical HOA, the association, people say, oh, well, they'll put a lien on my house. When I die, when I sell my house, the association will get paid. Well, the association can't operate. If everybody did that, the association would not be able to operate, right? And so that's why you see a lot of these associations converting or attempting to convert to POAs.
Don't do it.
Because condo associations and POAs don't have to wait. They can file the immediate lien and foreclose on the property.
You're giving up some of your rights if you move to a POA as a member. So you're consolidating the power further into a few people. So I'm totally against it. I want to make that obvious. Now, if you look at the collection aspects of it, notice here, these are requirements. Like now you have to be notified by certified letters. And what was the other term? Certified letter? or-
Statutory overnight delivery.
That one, statutory overnight delivery, right? So I remember getting a violation notice by text. And I was like, I'm not even a big texter. So I contacted them and I said, look, you can use text and email, but you have to send me a certified letter. That's what's specified in the governing document. So you want to hold them to this. If this is not taking place, this should be a part of your complaint, because you have the right to know what they say you owe, because maybe you paid. Hopefully you got the proof.
Well, and also you have 30 days to cure,
30
right?
days.
So after you have 30 days to make a payment or cure whatever the default is. Attorney's fees charged has to be an itemized list of attorney's fees. They can't just say, oh, you owe $1,500 in attorney's fees. They have to itemize those attorney's fees.
And it has to be approved by the judge.
And it has to be approved by the judge. It has to be reasonable in the judge's eyes, right?
Right.
Or the administrative law judge that'll be coming through the Secretary of
Just to
State.
share the experience of one of the latest families I've spoken with, they paid their overdue balance back in 2018. They were blocked out of access to look at their account, and now they get a letter saying they owe $10,000 after they've paid the other overdue balance. But, here's the kicker. This is going way past July 1st, and they just getting this $10,000 bill. My first thing to her is, hey, keep note of it. They have to give you an itemized bill. In fact, my community just sent me an itemized bill that include the fines for the numbers on my mailbox. Okay. So they are trying to abide by it, but the point is, Senate Bill 406 is now saying, hey, you don't have a choice. This is the process you have to follow. Now, I'm not getting any new fines because I brought something to their attention that we did when we was on the board, which was replace all the mailboxes in our community. And now we have a number of mailboxes with the numbers falling off. Who owns that would be the question that I would put before the courts. I mean, 2 numbers, $1,700. Man, they trying to take my drone money. I'm moving on. So, okay.
Years ago, I did a report because I had mailed like 80 houses in my community had only 1 or 2 numbers. It's against the law to not have the numbers correct on the house, the mailbox, or on the curb because it's a problem with first responders.
Yes.
Mine's on the big brick.
It's
Nobody running into my brick, though. Right. Thanks for that, and make sure I do some research on that one.
Yeah, so Mr. Driscoll's right. What we did,
I just did my research.
we went through the declaration, and the declaration said that it was the association's responsibility, but it also said the association may. So what we did in our community, we didn't like the way they were responding, so Mr. Driscoll and I ran for the board, and we took over. It boils down to 3 things in life: lead, follow or get out the way, right? And so we didn't like the way that we were being led, so we offered ourselves to lead. And that's how we took over our board, right? We stood outside the front and gave away coffee and donuts and got all the
Roses.
and roses and got all the signatures that we needed for the petition. When we walked into the meeting, we had already stacked the deck. We had 60 signatures. We had 60 proxies.
Yeah.
We had 60 proxies when we walked into the meeting. There were 60 people at the meeting. Half of them were with us and half of them were against us. So we had 75% of the vote by the time we walked in. We had already stacked the deck.
Yeah, that vote still ring true today. I'm still paying. So, but you all, from the financial standpoint, board members, give them the financial information, because that's where most members who have bad intentions like to look for a weakness. Document, dot your I's, cross your T's. Receipts, keep all of your receipts. We used to send ours into this company called Shoebox to help keep up with them. I don't know about anybody else. I have a problem with paper, except today.
So I think that brings us to our question
Yep.
and answer period before we get into
Is it 10:30?
our break in about 7 minutes. So I see one hand in the back, and I think we were going to have. We see all the hands. We just need a little help. Give us some time and try to, before we go into our break, unless y'all want to skip break and do all question and answers. Yes, ma'am.
Thank you all for hosting
Who
this.
has the mics?
Are you able to hear me?
Yes.
Okay, so I had a question about special assessments in particular, because this is what doesn't usually, at least for me, didn't appear in my homeowner's contract when I was purchasing the house, right? So what happens in that case? I know dues, you're required to pay dues, right? So in the case of special assessments, what do you do if that just comes about? Like almost out of nowhere.
So it probably was not in your purchase agreement, but it is in your recorded declaration. And because that declaration of protective covenants is
It wasn't there.
well, well, here's what I would say, right? I'm just, you could use an example of a condominium association and the elevator goes down, right? The board has the authority to levy a special assessment to pay to fix the elevator. And all homeowners, it should be done as a board member. You should be doing everything equally. You shouldn't be assessing it against any one particular person or unit unless that is more of a specific assessment and not a special assessment, okay? But special assessment should be for something like that, or the gate breaks at the front of the subdivision. Someone runs into it, knocks it down. There could be a special assessment assessed against all homeowners for payment of that bill. With SB 406, the new waterfall schedule, your payments would first go to your regular dues, and then I think it goes to special assessments, and then specific, and then all other late fees, interest, and attorney's fees in that order.
So if I can add here, special assessments are for special projects. It is not to be used for operational costs. This is where a number of board members have made mistakes based on advice from management companies. And so if they clearly state what's the purpose of that special assessment, because they have the authority, then you have to pay. But if they're not following those rules of the governing documents, I would say challenge it. Because I'm going to challenge my community. They
Yes.
doubled my dues.
So in my community, sorry, can I ask?
Let's get in as many questions as we can, and we can follow up more specifically.
follow up.
But the main thing I want to tell you all, as board members, you operate the association. As board members, you operate the association. Part of the biggest problem that, for at least from my perspective with HOAs, is that the management companies and the law firms have hijacked the HOAs from the homeowners, and they are using them as profit centers. Now, that's not necessarily a bad thing, right? They're in business to make money. But you, as a HOA board member, have the responsibility to make sure that you don't allow them to hijack your community.
And that's plaguing us.
They work for you. You can hire or fire them at any time.
Yes, I have a question regarding the registration fee. Our association is already registered with the state Secretary of State's office. That registration is due April 1st of every year. Now, this registration is due December 31st. How does that play into
So
what
you-
we pay ordinarily once a year as
So
in
that
addition
is
to this?
you are probably absolutely correct, right? Your normal registration is for the nonprofit incorporation. That is not registering as a HOA that can collect dues. This is a new process that has been established. So you're going to have to pay your registration to keep your incorporation with the Secretary of State every year. Plus, you will have to pay an additional $100. The HOA will have to pay an additional $100 each year in order to collect dues.
Okay, and then we're already, we already pay taxes every year. How does that play into all of these things that are required now by the Secretary of State? We got to do that in addition to
The
paying
HOA
taxes
does. You as an individual do not.
No, I'm
but
talking about the association.
but the
pays
association-
taxes
the-
every year.
Oh,
We
so-
file income taxes,
Well,
both state
there's-
and federal.
most associations are nonprofit
They
incorporations
don't
and
pay
should not be
taxes.
paying taxes.
We
Right.
don't pay anything, but we file income taxes, state and federal every year.
So,
Okay.
so again, these are new requirements, even in the governing documents. It prepares you all for the fact that things can change. And so this is where you have to adapt. Plus, you pay for a management company, I suspect. If you pay them, they are supposed to help with this process.
We've only got time for one more question before the break, but we will have more questions. If you don't mind, write your questions down. We can try to answer as many of them we can during the break and or at the end. So thank you.
Okay.
And you can hand the questions and we can,
Okay.
And I'll be speedy. This is really a question. I'm working with on a working group with the Secretary of State.
Oh.
There's a working group that's inviting input into the framing, helping with clarifying the regulations. So that work is already underway. And we've already had our kickoff meeting, and then we have our next meeting. So it's in process. So there's a room full of attorneys, property managers,
See?
homeowner boards. So it's in process.
Okay. I'm glad to hear that.
Glad to
be
know we
honest.
have someone from DeKalb in the room. I wasn't aware
Yeah,
of
thank you
that.
for coming. Look, I appreciate the info.
you think we got time for one more or no?
They're stacking it against us.
One last one before the break.
I think it was her, right here. Oh, she going that? It was her. And she went to the back.
Oh, you have one already? Is that what it was?
No, you promised her.
Oh, okay.
You promised her.
We have more opportunities.
Yes, you did. I'm sorry, this is going to be very quick. You mentioned records and that you're taking your printer. What if the residents request to have it sent to them electronically? Do we still have the right to charge?
I mean, the short answer is yes. Typically, what has happened, though, again, remember I told you the management companies and the HOAs have hijacked the HOAs because what happened is the management company or the law firm actually charges for that, and the HOA doesn't get any of that money, right? And you know, they're using it again as a profit center for either the management company and the HOA. And frankly, you know, they have the management company has the right to mark it up. It might not cost them but 5 or 10 cents per copy, but they have the right to charge you 25 cents or $1 per copy, right? Just be mindful of that. Don't let these companies tell you what to do as a board. The board should be telling the management companies and the law firms what to do. The law firm or the management company say, hey, we need to foreclose on their house, but you as a board can say, hey, that's our neighbor. We want to take a more neighborly approach first.
I was going to say that. Thank you for saying that part. Take a neighborly approach. You still a neighbor. You still live there.
I think that brings us to our break time. So let's take a nature break.
Full session, very informative. Now we're going to go into all things code compliance. I just have one favor to ask you. As we go through the presentation, because we are in a crunch for time, and we do want to get through all of the information that's prepared, I think we have one other session after this. So if you can do me a favor, jot down your questions on a piece of paper, on the back of your presentation, whatever piece of white space you have, and I promise I will address your questions in the end. Is that fair? Okay, thank you. Okay, so the first thing, I forgot I gotta do the clicking. Okay, here we go, we're clicking away. So, the first thing that I wanna do is go over our mission, because this is important. As we do what we do, and we reimagine what code enforcement can look like in DeKalb County, I wanna assure you that code enforcement is not the same code enforcement that it was 5 years ago, 2 years ago, or even 6 months ago. It wasn't the same code enforcement it was yesterday, because we are growing, we're evolving, and our mission is to serve the residents of DeKalb County by enforcing the codes established to protect your public health, safety, and welfare, while enhancing the quality of life with professionalism. That's what we're bringing to the table. Timeliness, we're getting out to those inspections faster than ever. We have set a goal of a 72-hour response time. And then the last thing is efficiency. Everything we do is going to be efficient. That's why we're not issuing as many warning notices, because we're getting cases to court quickly. So when we talk about timeliness, when I started in May of last year, we had about a 14-day response time. And I can tell you, as we sit here today, we have had consistently, from June of last year to current, consistently between a 3-day and a 2-day response time, and we'll continue to do that. So understand what that means. That does not mean that the issues are going to be resolved in 3 days. 3 days by the time you contact us, that we're going to get out to the property. Now, the length of time to bring the violation in control, or to get that violation corrected, we work as quickly as we can. However, there are many factors that influences that. And as I go through the presentation, by the end, you will understand exactly why it takes so long to sometimes for you to see results. So the objectives, and I'm just going to go through this very quickly. And I'm just noticing something. I'm going to skip through some of these slides, because I don't think this is the right presentation. Okay, I'm going to skip through the slides. So let's skip that. The codes that we generally enforce, and this is not an all-inclusive list. We have all the codes. We cover and we touch just about every department in DeKalb County you can think of that we work closely with. We enforce several codes for several different departments. So when you talk about property maintenance, that's the main thing, meats and potatoes of what we do. But also zoning regulations. We enforce all the zoning regulations in unincorporated DeKalb. All of the sign regulations, permitting, business license, solid waste, litter on private property, not public property, throwing trash out the window in a moving car, that's not us. Illegal dumping, noise regulations, and there are many more ordinances. So we work with Department of Solid Waste Management, we work with Roads and Drainage, we work with the Police Department. Those are all agencies that we enforce their codes, or we enforce them to get a plan of sustainability. So we're a very busy department. We're probably, as far as scope, We have the largest scope of what we enforce, probably in the state of Georgia and in the United States. When we go to conferences, people are really amazed of just how much we cover. And so the common violations that you will see that we enforce, the high weeds and grass. If we took a snapshot of what our issues were in DeKalb County, I can tell you at any given time of the year what it's gonna be. DeKalb County, we have a high weeds and grass problem. That means people are not cutting their grass. We have an open storage of trash and debris problem. That means people are throwing stuff around their yards. They're not picking up the trash. They have the sofas on the front lawn, in front of the driveways, things like that. And also inoperable vehicles. Those are our top 3 violations that we have in this county. And hopefully, we can weed ourselves out of that and reduce the number of occurrences of those violations. So, high weeds and grass. You cannot have your grass taller than 12 inches. And as far as what you cut and clear, 150 feet from the structure. So where your exterior wall ends on your property, it has to be cleared 150 feet. Now, keep in mind, most of our properties are not that large. That means cut your entire property. I don't want to hear, that this 12 or 14 feet, is the area that you have, the swing set, but everything else is the wooded area. It has to be clear. That's the code. Storage of trash and debris. You cannot have your barbecue grill stored in a front yard. You cannot have the lawnmower stored on the side of the house or in the front yard. It has to be contained. You cannot bring, like I said, your sofa from the living room because you bought a new sofa and you don't want to pay the collection fee for waste management to pick it up. So now you have it on the front porch or in front of the driveway. It's considered open storage of trash and debris, and we will issue you a citation for that, unfortunately. Parking on unpaved surface. Some people, they will put gravel on the side of the property to extend the driveway. That is fine. But understand that that has to be refreshed probably annually. The minute we begin to see the grass growing through that gravel, it is no longer considered an impervious surface, and it's a violation. So you can have gravel, but it has to be thick enough to where it blocks anything from growing through, and it blocks anything from leaking from that vehicle getting into the groundwater. Then we have our unregistered, inoperable vehicles. And I know for some of us, we have sentimental value with things, particularly old things. And we will have that car and we will promise ourselves that we're gonna restore it for our grandchildren or our children when they get old. We never get around to it. If that vehicle's inoperable, it either has to be running and you gotta be able to crank it up and move it. If we come out there, you can't tell us it runs because we're gonna ask you to crank it up and move it. If the tires are flat, it's inoperable because you can't drive a car on flats. So, and don't think you can cover it up and then we see the grass growing through the wheels or around the wheel well, or the dirt has collected and formed a little foundation around the wheel. It's inoperable because we will ask you to move it. Vehicle repairs. If you're gonna do any type of vehicle repair, it has to be in an enclosed space, like your garage. It cannot be in your driveway. Parking business vehicles in residential areas, same thing. If you see it, give us a call, we'll come out. So your box trucks, your 18-wheelers, that sort of thing, you can't have that in a residential area. Number one, it tears up the driveway, it also tears up the streets. Our regular streets cannot manage or handle that type of heavy load. Vacant and unsecured properties, nothing wrong with having a vacant property. That's not a violation. but that property has to be secured in a manner to where someone cannot break into that property, cannot be accessible by someone. There's a certain standard in which you board properties. And in the upcoming months, we're going to introduce legislation to basically adopt boarding standards along with our IPMC code that we currently have adopted, but we didn't adopt the boarding standards. We do still require you to board, but the boarding standards is a specific way in which you board a property. And there's illustrations and step-by-step instructions. So that way, if you just put the plywood on the front of the property and you nail it in, then someone is gonna come, pry that off, and gain access to the property. With the boarding standards, you have to secure it from the inside with 2x4, and there has to be a certain width of the bolts and the screws to anchor it so it cannot be removed. So, also with the vacant unsecure properties, we have to make sure that they're maintained. Make sure the grass is cut, so you can't just walk away from a property. You have to make sure that you're checking on that property. Grass grows very fast in 2 weeks. Weeds grow very fast in 3 days. So, 9 out of 10, if you have a vacant property, you don't have grass anymore. You have weeds that's growing very fast, especially in the growing season. So the properties have to be maintained. We also enforce commercial properties. What we look for in commercial properties are basically signage in the windows. You have to have a certain amount of signage in the windows, no more than 30%. If it's more than 30%, it's in violation. There's a reason for that. There's a safety reason for that. If the police or something's going on the inside and the police is driving by or anyone is inside, you could be in there getting robbed. But when you have signs covering the entire window, no one knows what's going on inside. And plus, it looks bad. So and there's also legislation that's coming we're actually rewriting the sign ordinance. And Madam CEO, if I'm not mistaken, this will be the first rewrite of the sign ordinance that we've had in about 20 or 30 years.
That's correct. And let me say to you that, in particular, you can look and there's certain businesses, restaurants, liquor stores, that tend to have lots of signage. And the truth of the matter is, if you're a liquor store or a package store, we know. I don't need to see a bottle in every window to understand what you sell. Mm-hmm. And let me also say that what I found in doing research is they're paid to create the blight. Mm-hmm. So they are paid to put Snoop Dogg in the can of Colt 45 in the window. So as far as I'm concerned, all of it can come down. So unless, the Board of Commissioners feels differently than me, I think signage, honestly, at most businesses, as we seek to clean up DeKalb, we can do without the inconsistency and all of the signs in the windows. Let's just take it all down and just put your sign up and say who you are, and I think that's enough for most people. So that's where I'm going with it, and particularly with certain businesses, because they're absolutely egregious. Gas and service stations tend to have that same problem too. Mm-hmm. Donuts in the windows and coffee, and we know you have it. You don't need to put it out there.
Yeah. And then in along the same lines with the signs, they have to be aesthetically pleasing. We have businesses where the signs are dilapidated, the business might be vacant, and you see those big marquees and they're rusted. Some of them have been hit by vehicles and they're leaning to the side. We understand, that you have vacancies, but trust and believe. If you can afford to own a strip mall or a whole shopping center or shopping plaza, you can afford to upkeep that marquee. And so I don't have any sympathy. And I drill this, home with my officers every day. We are in a different line of business. We are in the business of enforcing. And because we're enforcers, we're not one of the departments that provides social services. Now, we will make a referral if that's needed. That's where we have community development, human services. You know, some of these other departments, you know, this county has a wide range of services that we provide to our residents. The service we provide are to our property owners, and that's through enforcement. So when we come out, that's what we're gonna do. So there's a cost with doing business, and part of that cost is the responsibility for the upkeep of the property. And so that is something, we have an entire team that all they do is commercial enforcement along commercial corridors. And we go up and down the commercial corridors, business by business, door to door, enforcing the code. We start on one end and we end on another end. Just this year alone, we've completed enforcement along Glenwood Road, Candler Road, and I can tell you, we haven't even adjudicated the cases. They're still in court. And some of them, they've corrected the violations, they're still waiting on a court date, and they're out of compliance again. But guess what? We get paid 40 hours in 1 week, and for 40 hours in 1 week, we will enforce the mess out of these businesses that's not in compliance. All day, that's what we get paid for, and that's what we'll do.
And let me add, Director, that we are not going to hold court in the driveway. When they show up with a violation, because what we found is we'd been issuing warning citations for years to the same people. And of course, when you issue a warning, then we've got to expend the gas to go back, and you're still in the same condition, and you ask for another due pass. Well, when we come out now and we visibly see a violation, we're going to issue the citation. Because what we found, if you had good intent, you're still going to remediate the conditions. So this will be of no consequence when you show up in court, because you're going to take care of it. But we're not going to try that case in the driveway, and you're not going to be mean to our officers. That's right. Now, if there's extenuating and mitigating circumstances, I do want to say that we lean in. If you're seniors, you know, in some communities, and particularly our older communities where I would say our legacy residents live, you have shingles that may be falling off, you have issues, then please share with us that you need help. Because we do have funds that are available and we can work with you. But you can just no longer let this condition continue, because it's affecting property values, it affects the quality of life, and it affects who people perceive we are. It just simply sends the wrong message. So yes, don't beat them up, and don't call me and say that they were trespassing when they came and saw the violation. Well, it was in plain view. We're just giving you notification that we saw it, you know? And I'm not going to scold them about that. They're doing their job, and we're really trying to make this better, the community, for everyone.
Yes.
If I can, you know, CEO Johnson, one of the other things, a lot of these code violations might also be covenant violations. And so you need to make sure, because there could be two times, right? But, you know, just be mindful of that, because a lot of the covenants are adopted from the code, right? And so just be mindful that something could be a code violation as well as a covenant violation. So you may have two bites at the apple if needed.
Yeah, and I'm glad you mentioned that. I'm going to segue into that, because we do get a lot of calls from our HOAs. And I want to explain the difference between covenants and our code of ordinances. So we enforce the code of ordinances. We have no legal authority to enforce covenants, individual covenants for the HOA. That's where the HOA's responsibility comes in. Only the code, because we do get, you know, requests. Well, our HOA says that you can't have the house painted this color. and they want us to write that up. Well, we have no legal authority to enforce that. That is with the HOA. And so that's the distinction between the two. We only can legally enforce the DeKalb County Code of Ordinances.
Yeah, anyone live in the community with the teal green house? Okay. Okay. Yes, we had an unfortunate situation, and I won't say, but it's a cultural thing, and they liked the color, and they painted the house teal green in an upscale community. And all the neighbors were in an uproar over it, but we don't have the ability, and more when it comes to planned communities, you might want to update your code and say they can't paint it pink, green, hues, or have those approved by you, because the county can't go out there and make them repaint the house.
Yeah.
Even if it is vibrant,
Yes. Yeah.
They do it.
And then also, we enforce business license. And so every property that does operate, every individual that operates a business in DeKalb County is required to have a business license. And so when we go out to do our commercial corridor sweeps, or if we get a call that you're operating without a business license, you're required to post the business license, not just have it. And we will issue a citation for that. Every year after business license renewal season, we get a list of all those properties who do not renew. And so my officers take that list and we go out just to verify whether or not that business is still operating. And if they're still operating, we will issue them a citation. There's no warning notice for that. We've been getting a lot of calls recently. Even someone filed a lawsuit because we did not issue a warning notice. We went straight to a citation. And I want to make it clear, there are only 2 codes in the ordinances that we enforce that says that we have to issue a warning notice. That is for inoperable vehicle and open storage of trash and debris. Every other violation that we enforce, we are authorized to issue a citation. And as CEO Lorraine Cochran-Johnson just stated, we have been issuing a lot of warning notices over the years, which is why you have not seen any improvement or not a large set of improvements over the years in the property conditions. Because I think we found one property, 13 years of warning notices, the same property, 13 years of warning notices.
And imagine they were angry when we issued the citation, and then accused me of having them trespass under my authority after 13 years of us talking to you. So, I made it clear. Now, if you don't want to have the notice, then you don't have to get it, but you're still going to show up in court. Now, how we do this is up to you, but we have people that have become very unreasonable.
Yeah.
And it just, honestly, it is reached a point of being egregious. And they're angry.
And even with those 2 categories I told you about, if you've been a repeat violator, if you've been in violation for the same incident in less than 12 months, then that goes out the window. We can go straight to citation. And most of our property owners that we have in violation, the vast majority of them, about 80% of them, are repeat violators. And so it doesn't make sense for us to continue issuing warning notice after warning notice after warning notice. The science doesn't make sense. At that point, we have to change behavior because you're not self-governing. But what I can tell you is the citations, when we issue those citations, they do bring about compliance. I just have to now condition my officers to not feel sorry for these folks when they go out there and they start praying with them and quoting Bible scriptures. And I'll just tell you, I called them on my neighbor. I sent her a courtesy email. And it got to the point where now my fence is broken. And she came out quoting Bibles. I'll tell it publicly, because everything we do is subject to open records requests. And she came out quoting Bible scriptures. So the officer called me and said, she's crying. What do you want me to do? What we do with any other resident, issued a citation. No one is immune. And if you want to stop at my property, and if I have everything out there, issued a citation. So I can tell you a personal story. I hauled my dad into court. The officer called me, said, I met your dad. What do you want me to do? I said, what do you mean what I want you to do? What does your training say? Issued a citation, but what he didn't know is that Mama called me to tell me he won't clean up the front yard. And after he got issued a citation, I told my son and my nephew, go over there and help your granddaddy clean it up. And he cleaned it up. That was about 1 month into this position. We don't discriminate. We follow the code. And that's the integrity that we have in code compliance.
And I have to also say that I've had a lot of business owners call because they've indicated, well, no one's been here for years. No one's ever said this was a problem. Why is it a problem now? And you have to point out, well, it's always been the law, but DeKalb is taking a more aggressive approach to bringing businesses into compliance. And I've had some that have said, because they've been comfortable for years, well, you all are acting like Gwinnett. And that is, to me, that is very insulting. You just insulted me because you wouldn't expect to do this there, but you have been comfortable doing it here. And now you have a problem when you have had a due pass for decades. Well, and 13 warnings, 13 years of warnings. So with that being said, we're not trying to be heavy-handed, but it is simply time. And to be honest, shame on us as a county, because we've contributed to the blight that we see. And we wouldn't be in this condition had we done something before now. And even that, I have to say, as far as I'm concerned, goes with the water billing situation. We have allowed things to get to a point where it's gone too far, and now it's difficult for people to come into compliance. So let me say to you, you know, with our new blight tax, it allows me to charge commercial entities 10 times the millage rate for looking a mess. So those monies are being put into a designated fund for businesses who realize I've gotten myself in a bind now because I need to make investments and I don't have the money. Well, you can apply for a grant from the businesses that I'm going to take money from for being a derelict of their responsibility, and we're going to meet you 50%. We'll give you a 50% grant to update your facade because businesses don't want to locate in communities that look, in some instances, the way certain parts of our communities do. So I'm going to help you help us, but you're going to do something.
If you can hold it till the end, I get to your question. Thank you. Yep. So dumpsters and compactors. So we also get complaints about this, and we have our fair share of businesses that are not doing what they're supposed to do. The compactors are not large enough to accommodate the amount of trash that they're dumping. They're not enclosed. And so the code basically states that every dumpster has to have an enclosure that is opaque. That means you can't see through it. So sometimes the question comes up, and I think we just had this question. What type of material? The code does not say it has to be a wooden enclosure. It has to be an opaque enclosure. So it could be the PVC fencing. It could be any material that blocks the view. as with all of these materials, you're gonna have a certain amount of width, centimeters or an inch, where you can see through. You don't have to have a solid piece of wood. So I just want to make that clear. Also, the way we enforce this code, the officer has to make a determination because not every property can accommodate an enclosure as written by the code. And here's why. Some properties, DeKalb has an aging infrastructure. We're a county where, some of these buildings have been up for decades, half a century or more. And so when that property was initially built, it was built before our codes were written. And so with that enclosure and that dumpster, that truck, that waste management truck has to be able to come in, maneuver. We didn't have the same trucks that we had, 20 years ago, much less 50, 60 years ago. So now the trucks we have to come in, lift that compactor up overhead and dump it. Not every property has the space and the width to accommodate that. And so we have to make a decision when we go out. So sometimes we're able to enforce that provision of the code, but sometimes we cannot because the truck can, if there is an enclosure built around it, the truck will not be able to come in and service that. And the property owner, has no control over that. So, and I don't like the word grandfathering, but it is something that is real. We can't punish a property who has been in existence before our codes were written. And so we have to look at the situation. So what we do is tell the property owner, what we need for you to do, you won't be able to put an enclosure, but you better have that dumpster. It has to be the sufficient size to accommodate your trash, and also it has to be free and clear of any trash and debris around it, because we'll cite you for that. So I just want to make that clear, because I know lately we've been getting a lot of calls about dumpster and dumpster enclosures. I think we had a whole sweep along Flat Shoals Parkway, where there was a complaint for the dumpsters. And that's something that, I just want to make sure that we educate our residents. So when you see it, maybe they can't accommodate a dumpster if it's just a small space. Illegal tire dumping. This is a problem that if I can pray it away, I think we'll all be in a better place, because this is an unfunded mandate. We have bad actors that are coming into communities, dumping tires by the truckload. 2 weeks ago, we passed a new scrap tire enforcement ordinance. It's a revision to our current code that's going to have more enforcement authority and more restrictive on tire handling businesses, because what we're finding out with some of these, and it's not your, prominent tire handlers, it's a lot of the mom and pop tire places, and I don't want to discriminate, but it's not just the handling of the tires. There are certain standards you have to have on that property. You can't have the tires stacked up and displayed on the front by the sidewalk or the curb showing that you sell tires. We know you sell tires. We see the dilapidated sign. We see the stack of tires on the side of the building everywhere scattered around the property, breeding mosquitoes. And that's a violation. All tires have to be stored in an enclosed container. They have to have an enclosed container somewhere on that property that stores the tires. And the tires have to be stacked in a certain manner so that if it rains, the water will not collect in those tires, breeding mosquitoes. And so we're enforcing all of that. That code goes into effect 180 days from you know, my math is not that good to remember when it's going to go into effect, but 180 days from 2 weeks ago, we'll have a stronger set of codes that we're going to enforce.
And let me say that DeKalb County, we just won a national award through the American Public Works Association, the highest honor that they give, because in 1 year, we cleaned up 37,000 discarded tires. 1 year. And although they did not want to be publicly acknowledged, I'm going to acknowledge Home Depot because they helped tremendously with the funding to do that. Now, this has become such a chronic problem for us. Just bring me the tires, because it's more expensive for me to send out crews, and we're going down hills and through rivers and valleys to recover discarded tires. So we just invested $1 million in the purchase of a tire chipping machine, because it's easier for me on the front end to take these tires. Now, also, we are beginning to enforce, because now that when you really get in the weeds, you find solutions. When you all, if you have tires that's discarded, when that company receives your tires, every tire has a serial number, and they should be recording the serial numbers. So now that we're dealing with the illegal dumping, what we're finding, we're now running the codes. And that's how we were able to begin determining which businesses these tires came from. So now we have a whole group of detectives. I have a tire task force, and we show up and say, we just got your tires from over there on Covington Highway. And that's when they would say, well, we paid so-and-so to take the tires. So the companies that should have been legally and properly disposing of the tires and taking the money from some of the businesses were taking them and dumping them in the middle of the night. Now, that's where also your flock cameras have been helpful, because we have eyes on locations. So we will literally follow you with a drone, because you hadn't committed a crime until you take the first tire out. But we see you, and we can even see the imprint of the tires in the back of your truck, so we know what it is. And then we go and arrest you. So we have arrested thus far 7 of the most egregious illegal tire dumpers in DeKalb County. So don't bring it here, because we're not going to play with you on this, because 37,000 tires, shameful.
Yeah, and also with the tire dumping, we don't have the authority to enforce against people. I call it crime of persons. That's where our police department comes in. So if they're dumping the tires, the police department can make an arrest. What we enforce is crimes against property. So the property's not in compliance. If there's tire dumping on the property, every property owner is responsible for securing your property. And I know that's difficult, because we have businesses that are operating. We have property owners that live on the property, and these people have gotten so notorious. They come into work to open up their business, and it's a stack of tires dumped. Or you're on vacation, and somehow someone knows this, or you may come home, and it's a stack of tires on your front lawn. That's what we're seeing now. And so what we're doing is our officers are going out right now. There is a requirement in this code that you have to have a manifest. The manifest, and it's in the current and old code, in addition to the one that was recently the one that was recently rewritten and adopted, is you have to provide DeKalb County with a manifest. This manifest basically states how many tires you've had, how many tires that you've handed off. It has the serial numbers for the tires, and you have to present that to our Public Works department. They then reaches out to us, and gives us a list to say, here are all of the tire handlers in DeKalb County who has not submitted a required manifest. We go out, at that point, the county doesn't have a record of it, and we go out and we issue them a citation for not submitting that manifest. What we have found since we've started enforcing that, and that is something the code has been on the books probably since Noah was a scout, I don't know, but what we found out is that all these years, the code was not being enforced.
And that's what I was talking about. I just didn't use the proper term. We are now requiring the manifest. No, I call it the tire log, but that's exactly it. So this has been on the books, and we've not been requesting them from the people that receive the tires. It was just unbelievable.
And so what we're finding is when we are tracking the manifest, because now Public Works, they're not just collecting it, they're looking at it. They're matching signatures. And what we're finding, the signatures are being forged. Well, that's a violation. That's criminal. We are not enforcing that, but the DeKalb County Police will enforce that. Then we also go to the folks that by law is required to accept the tires. When we ask them that so-and-so company bring you this amount of tires, some of them, they're telling us they can't do this type of business anymore. They're in violation of some type of state code, and so they've been barred for hauling tires. And they cannot come to any of the properties because of whatever violations they violated, whatever state code, but the businesses, they don't know that. And so there's a reason why we have to enforce these codes. There's a reason why we have to follow the trail, in this case, follow the tire. Because now we can see, that there is fraud and identify where the fraud is occurring. So guess what? That case can now be turned over to the police for prosecution, because I guarantee now if they follow that trail, they can see where this company's picking up tires from, and we know that they're not dropping it off at the approved folks that's supposed to be accepting the tires. So where are you putting the tires? Are those the tires that's, down in our ravines and on the side of the road? Possibly. But that's where the criminal investigation, now we have a way to track and start convictions, start charging people and getting convictions on some of these things. I'll get you in the end. Just jot your question down for me. Thanks. So, that along with litter, we are enforcing all that. So I want to go very quickly because I've been talking a lot. And I want to go through the process, the enforcement process with you. When we receive a complaint, we have many ways of receiving a complaint. You can email us. You can come into our office. We're located in the building right next door on the ground floor. You can come into us and bring your complaints. You can call us. If you see our officers out, you can submit a complaint through them. I suggest don't always do that because they have so many properties they're trying to get, but you can, and they will accept it. But if you call it, you can even go on the website and submit your complaint. And in the back of this presentation, and also you should have gotten these flyers. It tells the same process, and it tells you how you can submit the complaints to us. We'll come out within 72 hours to launch that investigation and take it through the courts. Once we investigate the property, we'll conduct an inspection, photograph the evidence, document it, and then we will take enforcement action. Again, more than likely, it'll be through a citation. Once that citation is written, it is then transferred over to the courts. I want to make this clear because we get a lot of this. Once we write the citation, why is it taking so long? They're still in violation. Code enforcement, you're not doing anything. This has been going on for so many years. Once we issue that citation and we submit that citation to the court, it is no longer our case. That now becomes a case of the state handled by the solicitor's office and is now a matter for the courts to adjudicate. Our only involvement at that time, and I'm going to stress that, our only involvement at that time is to come to court and serve as the state's witness as to what we observed, what action we took, and what needs to happen to bring the property into compliance. If that case is reset until next year, if that property owner requests a jury trial and is bound over to another court, we have no control over that process. We also cannot compel people to clean up their properties. All we can do is enforce. We can take them to court and hope that they will do the right thing and clean up the properties. So I just want to make sure that we have an understanding of how this process works. And in the meanwhile, you can call us. We will continue to go out and document
That's right.
that the violation is occurring. You know, it's not going to stop, the neighbor, next door who's working on cars to stop doing that activity. They may continue working on cars, but we will continue to cite them and submit these citations to court.
And let me also add something here, because this for us becomes a slippery slope, because we have 3 different divisions of government: your executive, your legislative, and of course, your judicial. And when things move to the judicial, I'm very sympathetic because, community keeps calling, I keep answering. But what it becomes for me is what the title is undue use of influence. I cannot call a judge and say to them, I need you to handle this. I have absolutely no jurisdiction over the courts. And when some neighbors truly believe they're helping, because each and every time you call me, if you call me, I'm calling someone, is how I work. Then we've had, in some instances, individuals recuse themselves on the day that the case could have been prosecuted. But because they feel that the pressure from my office and the people were so great that they can no longer exercise their right to make a decision fairly. So I have seen cases be completely reset and start all over again, because the judge in the case and those who were responsible said, I can no longer handle this case. I'm walking away from it. We'll have to send it over to a new judge, or it will need to be prosecuted. And then here I am still getting the calls. And we've started all over again. So give it time, and I wish there was a different way, but it is what it is. Once it goes to the courts, I can't sit there and adjudicate the case.
And so once that case is fully adjudicated, if the case is in compliance, well, let me say this. Once case is adjudicated, we have to close the case, because there's something in the law called double jeopardy. And we can't try you twice on the same case. So we have to close the case. So when you submit an open records request or you call and they say the case is closed, that is by law, we have to do that. However, if the case is not in compliance, we will open a new case. So if you call with the same old case number that's been adjudicated, you're gonna get that case is closed. We will open a new case, and then the process, unfortunately, it starts all over again. So that is basically this process. We're running close to time, and I want to get to your questions. I want to touch on one other thing, is that we have several ways of dealing with cases. I want to talk about our in-rim process really quickly. There's the adjudication where it goes through the courts. On a lot of our vacant, abandoned properties or our demolition properties where we cannot locate the owner, if we locate the owner, but they refuse to do anything about it, then we have another mechanism in place. And it's called a complaint in rem, which is a legal process where simply we then package up that case, present it to our law department. They then will take the case through to the courts and ask the court for a court order to allow us to go onto that person's property to either demolish it if it's necessary. It has to meet certain conditions for that. Cut the grass, board up the property, secure it. Now, we're not going to rebuild the house. We're not going to paint the house, but we will secure it in a manner to where, vagrants cannot access the property. And we'll cut the grass, and we will maintain the grass, but there's a cost to doing that. You don't just get away with that scotch-free. Every cost that's incurred in that process, including attorney's fees, will be assessed against that property in a lien. So you're going to pay for it either way. Either you pay for it now, which will probably be cheaper for you to go ahead and hire someone to cut the grass, or if we have to do it for you, you're going to pay.
And let me announce a forthcoming lien sale in DeKalb County. Because we do not make our money spending taxpayers' money to handle the responsibility of other property and business owners. Mm-hmm. We have millions, upwards of $20 million in liens. And no one is rushing to pay us. Honestly, until the house is being sold, usually that's the day I get the urgent email saying, what can I do to satisfy this? How dare you have this lien on my property? Well, how dare you not pay it? It's been there for 13 years, and you didn't pay attention to it then, but now, and so with that being said, I am making this announcement, and I mean it. We are looking for a company. I'd love to sell them all off at the same time. And then you can deal with that company, and we'll see if you have more urgency in paying them to recover your property than you've had for the taxpayers that have done what you didn't by not taking care of it. So we have to go knock it down. You've been seeing us take these homes down. Usually they average about $23,000 is the cost for a demolition. All because they didn't take care of their property, and now we've had to do it. Well, you're going to pay for that.
Yeah. And how do we do all of this? So we've had to expand our operating hours. We are now operating 8:30 a.m. to 8 p.m. because there are certain violations that cannot be observed from 8:30 to 5. Your neighbor that brings that 18-wheeler, he's on the road all day. After he drops off his load, he's usually not coming home until late in the evening. Sometimes we can't catch him because he's coming in at 11, 12 o'clock, 2, 3 in the morning, waking you up with that loud motor. So, we are expanding our hours. Usually the basketball goals, it wheels out, or the kids are in the cul-de-sac playing basketball after hours, so now we can catch them. Same thing with when they're working on these vehicles. A lot of that stuff happens after hours. And so Monday through Saturday, we are conducting inspections from 8:30 a.m. to 8 p.m. Our office is open Monday through Friday, 8:30 a.m. to 5 p.m. So please don't come to our office at 7:30 p.m., but we are conducting inspections at that time. On the slide, you'll see all of our contact information, including our website. And I want to say, what we're doing, education is key. And so when we come out to these events, we'll have a table where you can get flyers. If you ever want a stack of flyers to distribute to your HOA, let us know. We will reproduce those flyers and give you how much you need. Also, it's available electronically where we can send it to you because, getting these things printed is very costly. And so to be more efficient with your dollars, we can send you the electronic copy and you can email it out to your HOA members. Every time we go out to a property and we take action, we are leaving some educational material along with that warning notes or citation. So not only are you going to get a citation, we're also going to tell you exactly what you need to do so we won't have to come back again. We can't do this by ourselves. We're asking for your help. we have this card. It's called the Good Neighbor Card. And I'll read it. It says, "Hello, neighbor." And so what we're asking, we've had this for a while, what we're asking is if you have an HOA, you can get it from us. This is how you partner with us, because we're in this together. We go to the same drug stores, we go to the same grocery stores, we may worship in the same places. So we're in this together, and we need your help. We can give you a stack of these cards, and basically, if your neighbor is in violation or your members, you can give them this card. It's not worded like our citation. It says, "Hello, neighbor, we understand that your home and yard can fall through the cracks because of busy lives and schedules. We love our neighborhood and need to keep it beautiful. Just a friendly reminder to cut your grass by such and such a date. Please take care of this issue to avoid involving DeKalb County Code Enforcement." And on the back, it has all of our common violations. So if you can get a stack of this, this is where we partner together, because we're not everywhere at all the time. So when you say, why didn't code enforcement see the violation? For the amount of residents we have and the number of code officers we have, we cannot possibly see every violation. You see it more than we do, so we rely on you to help us. So if you need a stack of these, just let us know. Okay.
And go canvass your communities and just take them to the neighbors. And if anonymity is an issue, then just, but we're doing everything we can to help you be a good neighbor. And please don't report to, what's that community website? Next door. What you should be reporting to DeKalb County. Please tell us. So get plenty of good neighbor cards.
So that's a real good segue, I think, into what I was talking about earlier. The answers to your questions might be next door or down the street, right? We have a lot of those same problems with tire dumping and things in South Fulton. So it's great to hear some of the solutions that you all are implementing in DeKalb, because I can take those back to South Fulton and implement them there. We do have some questions. We want to try to get through as many of these questions as possible. I do want to also give out our website. We got a couple of websites that we want to make sure that everyone gets. Our HOAalliance.org, HOAalliance.org. And then we also have Georgia HOAalliance.org. And we've got the HOA Bootcamp website, but it probably needs updating. We've been updating the Alliance websites and not the Bootcamp website, so we will do that. But make sure you check out those. Also, I wanted just to ask Rod Frierson to stand up one moment. He's been coming to our HOA boot camps for a while, and he's over in Hidden Hills Civic Association. And it is a volunteer community. And Rod, if you just take 60 seconds to tell people what you've been doing and show them this great flyer you have, that would be great.
Microphone, please. It's
Rod,
coming, Rod.
Okay.
Yeah, thank you so much for allowing me this opportunity to share with you what we have done in our community to improve our HOA and improve the interaction with our residents. Rod Frierson, president of Hidden Hills Civic Association. We have 1,640 homes in our community. It's pretty large. I've been the president for 12 years. I've been to this boot camp from the very beginning, so that means I've been coming here almost 12 years. When I first came, I started using some of the things that we talk about to implement best practices in our HOA, and I just want to share with you just a few of those if I could. The first one is we started talking a little bit about budgeting information and how you share it with the community. We do these postcard mailings 4 times a year to all the residents who live in our community to share with them what we do with the money that we receive as a civic association. That helps communicate our value. The problem that we have in our community is people don't know what we're spending our money for, and they don't see what we do with the money. First thing, my number is on this card also. If you want to reach me and have some conversations about what we do and how we've improved our community, I want to share that with you. The second thing I want to share with you is that every time we did something in our community that we spent money for, we put a sign out there that said, your dues paid for this. So everybody who drove through saw improvement. That communicated even more about what we did and just added value. When I started at as my association as a board member, we were bringing in roughly about $65,000. We only had about 200 members. Last year, we brought in over $260,000, and now we're at 85% members contributing to the association. We moved from a voluntary association to a hybrid to a mandatory due association through consent of owners. So they signed up to be mandatory. They signed up to participate in this. Why? Because they could put their hands on the improvements that we made. A lot of times I think HOAs don't communicate that well. So we sent out another postcard. These are the projects that we did. This is where your money went. You can see them. How do you like what we've done? And then on the other side, we report by phase how much your phase is contributing to this effort. So this is basically what people pay in their different phases. We don't list their names. We just list their phase and their address. So if you're in phase number 13, 49 homes, you pay 72% of your dues in that space. That just breaks it down in a smaller place where people now can say, okay, we in this cul-de-sac are doing our part. How do we encourage other people to do the same, right? That's through communication. And finally, I want to share with you is that we work in cooperation with code compliance. We send out a little courtesy notice to those who are not in compliance in our community. We list all the things that she has on that card from code compliance about how you can be a better neighbor. And this is how we deal with some of those issues. Just a courtesy notice. Sometimes when they get one of these, they make the change. They deal with the vehicle. They deal with the trash. They deal with the high grass. We approach them in an empathetic way. Not heavy-handed, but that this is our community and our responsibility. If you'd like to talk to me about that, I have one of these cards here. Please reach out to me. I'd love to share with you about what we've done. And we want to partner with you like we do now with Lance and the Rock Bridge Coalition, and how we can, in a very effective way, improve our communities and make them run better. Okay, sounds fair?
Thank you, Rod. It has really been amazing seeing the transformation that Rod and his association and all that's been done. I want to try to get through as many of these questions as we can. How do you redirect unruly board members when they refuse to do their duty? My mother said, kill them with kindness. Other than calling the secretary...
Report them to the Secretary of State.
Other than calling the Secretary of State's office, is there another telephone number because no one answers the phone? I imagine that there's going to be the Secretary of State is going to have an online process. Like Mr. Driscoll, I like doing everything in writing so that I can have a paper trail for later. You can't prove that you called someone. It becomes he said, she said. What should a community do when the board refuses to conduct its financial audit or has never had one? I don't know that most declaration and covenant documents, HOA documents, do not require an annual audit. It might be a good practice, but a lot of these associations don't have the money, don't have 1,600 homes. Rod, you are definitely going to be president forever. You'll never get a quorum with 1,600 homes. But I don't know that there's a requirement for annual audit of records. But hopefully most people HOAs are having to hire a CPA or have someone that can do their records and books for them. Can or how should a community freeze annual HOA fees when expenses are not transparent? Again, as homeowners, you have the right to elect board members. You have the right to remove board members, but those are really the only rights that you have, right? The board makes all of those decisions. You don't, as a homeowner, you don't get to make a decision for the board, but you can elect and/or remove those board members who have been elected. Should the management company control the voting process? The management company, again, does not control anything, nor do your lawyers. The board, you are in control. The board tells the management company what to do. The board tells the attorneys what to do. The management company and the law firms should be making recommendations to the board, and the board should be approving those. And I know we're all busy and don't really have time to go through all that stuff, but the management company is not in control. The board is in control, and you can tell them what to do. How long should fines stay on your records? You know, I think if there's a fine, it stays on if you're a homeowner, you get fined, it stays on your record until it is paid or resolved. One of the things that a lot of times that we're able to do when we negotiate or represent homeowners is to get the board to agree to waive late fees and interest. Typically, they won't waive attorney's fees because that's what they call a hard cost. But late fees and interest are what we call soft costs. Basically, they haven't incurred that expense. It's just kind of extra money or a profit center. And so a lot of times you can get the HOA to waive the late fees and interest if you are willing to go ahead and pay what you owe on your dues and or specific or special assessments. Are there any specific requirements for community, neighborhood associations? I don't necessarily know how to answer that one. I think, you know, this whole talk has maybe answered that. Can a new owner be grandfathered into a huge DeKalb water bill and other community building not being maintained with the HOA? I'm gonna leave that one maybe for CEO Johnson to answer. How can a corporation or LLC purchase an entire community? Just like anyone else. You buy 100 acres or you go buy 100 homes. You set up a closing, you got the money, you can do that. How will the Secretary of State select the folks that will arbitrate complaints that come before them? I don't know that we have the answer to that question, but we do have someone in the room who is involved in that process. But like I say, it is similar for me as a lawyer that also handles DUI cases. When someone's licensed, someone gets a DUI, they get a DUI, but a lot of times if they don't blow, they also get their license suspended, and they have to request a license suspension hearing from the Office of State Administrative Hearings, and they already have judges down there that hear those license suspensions. I imagine that there will be similar judges for this process. Administrative law judges. Disclosure of vendor contracts. Is any info in the vendor contract confidential, or is the board required to disclose the complete contract? I don't know that the board is required to disclose the complete contract, but again, if you are a board member, I think you should have access to that complete contract, but not perhaps every specific homeowner.
Well, that's amazing. HOAs have a security the county doesn't. If you want any contract we have, we're bound to give it, turn it over to you.
I think it boils down to the governing documents.
Violations, right? So if I have 5 vendors that bid on the contract, and if I disseminate that, they can use that for a competitive edge. So for the HOA, you can view the contract, but you can't disseminate it. You can come in and you can look at it, but you can't get a copy of it because then you got to
I thought they were saying ex post facto after the contract is awarded.
Yeah, so HOA,
Okay.
if for HOAs, your contract, say you open up something for a bid, you cannot share those bids because it gives the other
Understood, but
contractor
after the process ends.
After we have selected the vendor, you can view the contract, but I cannot disseminate that contract to you. So you can come in, I can sit in my clubhouse, and you can come in and look at that contract and read it, but I cannot disseminate the contract because it still gives an edge.
I'm glad
So-
you
so-
mentioned that,
Go
because
ahead.
that's what many board members use to deny requests for contracts. But if you look at your governing documents, like in my community, we have broad access above and beyond the state law.
And what I was to say, it goes back to your individual declaration, and it's also kind of like the thing CEO Johnson was just talking about. Different administrations can enforce different things. Different administrations can interpret the laws in different ways, and so it may just depend on who's in charge at that time. Again, lead, follow, or get out the way. Can an HOA be dismissed if by a vote of homeowners were not in compliance? I don't know that the HOA cannot be dismissed. The HOA is the association, right? Now, board members, there's a process by which board members can be removed. Typically, it requires at least 10 or 20% of the homeowners to call a meeting for the removal of a board member. But then at that meeting, you need at least 51% to actually remove them. So be careful, because you can call the meeting, but you might not get them removed. All right, let's go on. When putting an amendment before the homeowners to be voted on, can we legally specify that a non-vote would be considered as a vote in favor of the amendment? I don't know that you can do that. I mean, a vote is a vote. People have the right to vote. I don't think you can interpret that a non-vote is something else than other than being a non-vote.
I got to add some value there. The way most of these communities are getting around meeting the minimum requirements is that they're not providing proxies. They're just requiring you to show up at a location. If you look at your governing documents, a proxy is an option, so you need to encourage board members to send out proxies to the homeowners.
And additionally, also, proxies are allowed under the Georgia Nonprofit Corporation Code. So even if your specific governing documents do not address proxies, proxies are allowed under the Nonprofit Corporation Code. And so your board, if they are complying with the law, should allow the ability for proxies. We have proof that a senior living home is operating in our subdivision. What are our options? Call Director Clark. Not CEO Johnson, because she's going to be sympathetic. CEO Johnson is going to be sympathetic. Director Clark is going to enforce.
But seriously, do send us the address, and we'll put some eyes out there, and it's certain of tell-all signs. If you got 15 trash containers, and also we're now recording the serial numbers of your trash containers. Those have been rolling off.
Oh, that's on that?
And we've been having a hard time getting them shipped from overseas. So now you get one container. If you have more than one, you should have received notice. You got to pay for it. If not, we'll take it back from you. But, you know. Not sure what a comfy house is, but we don't want them in DeKalb, I can tell you. So, no comfy.
So we got 3 more questions. I want to. Okay, the bill is ambiguous in certain areas. Records are required to be held in an office space. We don't have an office space or a community center. We would have to store in someone's house or a drive. What address should we provide? I think you can have a virtual office nowadays, and I think you could, likely do that via Google Drive and have the information available via Dropbox or Google Drive, or if you have a clubhouse, you could use the clubhouse address,
Like
right?
a room. If I may aid, board members, don't put any records in your homes. Don't expose yourself like that. I'd rather go and rent a space to put those records in there, because again, management companies usually keep it. They're responsible in some scenarios, but ultimately, who's accountable?
We're over time, 4 minutes, but we got like 3 more questions. Will board be required to have open monthly meetings? Again, you have to look at your specific documents. Typically, most require maybe quarterly or annual meetings. Monthly meeting is a lot. It probably feels more like a weekly meeting when you're doing it every month. The bill is mostly focused on protecting the board's abuse with fees and legal situation, but it's not very focused on negligent misconduct. How will we know how to report negligence if we don't know what counts as evidence, because there are no rules in place? Those rules are being put in place, and so hopefully we will all have a clearer picture of what those rules, regulations, and procedures will be as we get closer to January. Any tips on getting homeowners more involved in the HOA/community? Yes, right. Events, hosting events is a great way to get people involved. And that's one of the things we talked about with Rod Frierson through the years. A lot of great ways to get people involved. Yard of the Month program, incentives, a gift card for the movie in the park, 5K race, yard sales, all great ways to get people involved in the community. And
Collectively, we call that community spirit.
Community spirit,
That's
yes.
what you're working on.
Can you recommend any reputable management companies? There are several good reputable management companies, several reputable law firms. Just be mindful again that they work for you. They work for the board, and you give them their directions.
Here's the shameless plug. We did include a request for a proposal in the HOA handbook. I think you should have them submit bids based on your requirements, and that's how you vet these companies. And don't forget references, legitimate ones.
And you can find a copy of the HOA handbook on our website at hoaalliance.org or georgiahoaalliance.org. So glad to see you guys here.
Or Amazon.
One of the things I was talking with CEO Johnson about is starting a DeKalb chapter of the HOA Alliance.
Oh, yeah.
So hopefully we have some great people here that'll be excited. Camille, Rod, and we're going to talk with CEO Johnson. Caroline, I apologize. So that we can expand and, again, share information across subdivision and county lines.
And I will facilitate that. Before I let you guys go, as we say in the Southern Baptist Church, with all hearts and minds clear, would any of you be interested in us hosting a separate workshop on budgeting for HOAs? Okay, because let me say, I could feel sort of in the spirit, when we talked about establishing your baseline for what your expenses are, go ahead and pull your documents so we can determine what your monthly yard, or shall I say beautification for your common areas are. If you have a water bill, let's get that all together so that we can come up with a baseline budget so you know what you're operating within, because it did really touch me. Many of you are experiencing increases in the cost of services. But because of these quorums and how these HOAs work, you're not able to increase the revenue. So you're in the same situation as the county. You're doing more with less, and the math ain't mathing. But let's sit down, because maybe if you create a document, because this is what I have to do to show folks, this is what we have. This is where our expenses are. Then maybe it'll help you in some way. So you'll see me do another email that goes out for a HOA budgeting boot camp. And y'all can come back and we'll sit here and work on creating budgets together. Also, I'm of the belief with some of what y'all have sent me as your governing documents, we probably need a workshop, and I guess I need to start hiring you to come up here, that would allow you guys to come in and we take a look at your governing documents. And I'm gonna, so I need to hire you, I guess, this time as an attorney and not as just a consultant that's coming up here on a Saturday morning, because I've heard many of you say loud and clear, you don't have the money to update these documents. So you work with what you have because you can't do more. So I'm willing to put county money, because county money is your money, to use to help you all. So let's,
Yeah,
I will do that as well.
We're actually doing that in College Park, with the city of College Park as well.
Great,
So,
so we need to do it.
yeah.
They gotta follow that.
Thank you all.
And last thing, thank you to Sonia, thank you to Dr. Davis, who's running around, everybody from the county that helps and organizes. We appreciate you. You guys be safe. Send emails if you need me, and be safe. Joel Edwards, hi there. Everybody go enjoy.